Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we're going to take a deep dive into the newly proposed federal data privacy law. It's been said that there's two things you should never watch being made: sausage and legislation. And I suspect that's going to be true here, as there's bound to be some negotiations and horse trading going on. But this bill has bipartisan support, and it probably represents the best chance Congress has had yet of finally getting a federal data privacy law on the books. So it's worth discussing what the bill proposes in its present form, how it would interact with existing state and federal law, and what it means for your cyber insurance and risk management program. Let's start with the basics. The push for federal data privacy legislation is not new. There's been a bill floating around Congress since 2022 known as the American Data Privacy and Protection Act, or ADPPA, but it failed to gain traction. What is new, though, is a discussion draft of a bill that was unveiled this past Sunday by members of both parties and both houses of Congress. This bill, crafted by Republican Congresswoman Kathy Morris Rogers and Democratic Senator Maria Cantwell, is being dubbed the American Privacy Rights Act, or APRA. And that's the focus of our discussion today. And folks, whether or not you support the bill, they clearly put some thought into this. They've introduced some concepts that seem to take into account the realities of how data is collected and used today. They define terms like affirmative express consent, distinguishing between practices which are necessary for an entity to fulfill an individual's request and practices that are for another purpose. They also talk about covered algorithms that can influence what information is displayed or delivered to individuals, dark patterns that can manipulate a user interface and impair a user's decision making, and unique persistent identifiers that can be linked to an individual through IP addresses, cookies, beacons, pixel tags, or mobile ad identifiers. They even touch that third rail of data privacy, biometric and genetic information. So the bill is fairly state of the art in terms of addressing the types of claims that businesses can find themselves facing. There are all sorts of provisions designed to minimize the data that businesses can collect and share, with requirements for covered entities to develop transparent privacy policies, and for consumers to opt out of having their data collected, with an eye towards the establishment of a centralized mechanism akin to the Do Not Call registry that was developed following the enactment of the Telephone Consumer Protection Act. Covered entities are also going to be required to establish reasonable data security practices. Although there's no specific reference to industry standards like NIST or ISO 27000, the bill does state that these practices should include vulnerability assessments, preventative and corrective action, information retention and disposal protocols, training for employees, and incident response planning. The bill also requires that covered entities designate privacy and data security officers, conduct annual certification of their controls, and biennial privacy impact assessments. Additionally, they need to exercise due diligence in the selection of third-party service providers, and those providers will be subject to the provisions of the Act, as well as the requirements of their clients' stated privacy policies. And at the risk of stating the obvious, businesses can't use the data they collect or the algorithms they develop to engage in discrimination. Now let's get to the part that has the plaintiff's bar salivating: enforcement. For starters, any violation of the Act is considered an unfair or deceptive trade practice, and the Federal Trade Commission can bring an action on that basis. They will also be able to collect penalties as part of judgments or consent orders and have them deposited in what is being called a victim's relief fund. This is important because that suggests that the penalties will be treated as compensatory rather than punitive damages, and that impacts their insurability in many states. As far as existing state and federal laws, The Act expressly states that it would not serve to preempt them. In fact, state attorneys general would be free to bring actions under their own state laws or under the Act, and the penalties imposed in one case would serve to offset the relief available in another enforcement action. Perhaps the most controversial provision, however, is going to be around enforcement by individuals. There are no statutory damages being proposed other than to bring those in line with what is available under existing laws like the Illinois Biometric Information Privacy Act or the California Privacy Rights Act. And businesses will be given 30 days advance notice as well as an opportunity to cure defects in their practices in order to avoid actions for injunctive relief. That's good, but pre-dispute arbitration provisions would effectively be nullified in cases involving minors, as well as those by any individual alleging a substantial privacy harm. What is substantial? Well, the Act defines that as financial harm of at least $10,000 or physical or mental harm that requires medical treatment. It also includes unlawful discrimination or what are called highly offensive intrusions into the privacy expectations of an individual. That leaves room for a pretty wide range of allegations that can be brought against businesses in spite of arbitration clauses. Now, there's a bunch more in this bill dealing with specific entities like data brokers and social media companies, but I wanted to focus here on the provisions that have the broadest impact on the private sector. And all of this is subject to amendments that work their way into the bill as it makes its way through Congress. I think the private right of action is ripe for such pushback from the business community, and there's no safe harbor provision for entities with compliant data security practices. But this bill is definitely worth watching. In the meantime, you're going to want to make sure that your data security practices are up to existing standards. Need a referral to a qualified privacy attorney? Please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.finz@alliant.com, and I'll be happy to put you in touch with several firms that you can vet for yourself. It's also a good time to brush up on your coverage for regulatory proceedings because, as I often point out, not all cyber insurance policies are created equal. There's a fair amount of variation in the wording from one policy to the next, and Alliant can review your existing cyber insurance policy and offer recommendations for improvement. It's just one more way that Alliant helps you find the more rewarding way to manage risk. Thanks for watching.